What's up, guys? Welcome to another episode of Real Estate Exam Ninja. Today we've got 20 more questions, 5 of which are questions that came from actual real estate exams. I hope this is helpful, and I look, guys, to seeing you in the next video. Ciao.
Number 21. A built-in microwave oven is an example of A. Personal property. B. A fixture. C. A trade fixture. D. An attachment. The correct answer is B. A fixture is personal property that becomes permanently attached to the real estate and is expected to stay with it when it is sold. Personal property is something tangible, movable, and not attached to real estate. A trade fixture is used to conduct a business and usually expected to be removed at the end of a lease period or when the property is sold. An attachment can mean anything attached to real estate. Number 22. You want to donate a piece of land to a religious organization. The title will pass when they complete building a church on the property. The estate is A. Fee simple. B. Fee simple condition precedent. C. Fee simple condition subsequent. D. Fee simple determinable. The correct answer is B. Fee simple condition precedent is ownership subject to condition that must be satisfied before title is actually conveyed. Fee simple is ownership without condition. Fee simple subsequent is ownership in which the grantor has the right to reclaim the property through court action if a condition isn't met after the title is conveyed. In fee simple determinable, if a condition isn't met, the property automatically reverts to the grantor without the necessity of court action. Number 23. The estate that grants the most complete form of ownership is A. Fee simple. B. Fee simple condition precedent. C. Fee simple condition subsequent. D. Fee simple determinable. The correct answer is A. Fee simple is ownership without conditions and is the most complete form of ownership. The other choices all have limitations. Number 24. An owner of a rental building is said to have what type of interest? A. Leasehold. B. Leased fee. C. Fee simple. D. Fee on condition. The correct answer is B. Leased fee is the most correct answer. The owner may have a fee simple interest or a fee on condition interest, but when a question involves leases, the most correct answer involves either leasehold or leased fee interest. The tenant has the leasehold interest. Number 25. Someone who has riparian rights on a navigable river owns A. Nothing. B. To the center line of the water. C. To the high water mark on the land. D. No water but to the center line of the land under the water. The correct answer is C. If the river is navigable, the property owner owns to the edge of the river or to the mean high water mark. If the river isn't navigable, the property owner owns to the center line of the water. You just have to remember this difference. Number 26. The term generally used to describe the rights a property owner gets when she buys a piece of property is A. Fee simple rights. B. Real estate rights. C. Freehold rights. D. Bundle of rights. The correct answer is D. The bundle of rights refers to all the rights a property owner generally gets when she receives ownership of a piece of property and is the most complete answer. The term fee simple and freehold refer to estates or interests that a person may have in a piece of property. There really is no such thing as real estate rights in the context of this question. Number 27. Unity of possession means that A. Each owner has an undivided interest in the property. B. Each owner took title at the same time. C. Each owner took title with the same deed. D. Each owner has the same interest in the property. The correct answer is A. Each owner taking title at the same time refers to unity of time, each owner taking title with the same deed refers to unity of title, and each owner having the same interest in the property refers to unity of interest. Number 28. What form of ownership has no right of survivorship? A. Joint tenancy. B. Tenancy in common. C. Tenancy by the entirety. D. All forms of ownership have a right of survivorship. The correct answer is B. This question can have a state-specific variation if your state does not recognize the right of survivorship in joint tenancy. But tenancy in common never has a right of survivorship. Number 29. Joe, Sam, and Fred are joint tenants in a piece of property. Joe sells his interest to Bob. Bob now has what relationship to Sam and Fred? A. Joint tenant. B. Tenant by the entirety. C. Tenant in common. D. Tenant in severalty. The correct answer is C. A joint tenant can sell his share to another person. That new owner becomes a tenant in common to the other joint tenants, unless everyone executes new documents to create a new joint tenancy. Number 30. Condominium owners generally own their land as A. Tenants by the entirety. B. Tenants in severalty. C. Joint tenants. D. Tenants in common. The correct answer is D. Condominium owners generally own the airspace encompassing their units in fee simple ownership. The land under and around the units is owned by all of the owners as tenants in common. A good way to jog your memory is to remember that condominium owners would want to leave their condo to their heirs, which is a feature of tenancy in common rather than joint tenancy. Number 31. Which type of co-ownership requires the signature of all owners to sell the property interest? A. Tenancy in severalty. B. Tenancy in common. C. Joint tenancy. D. Tenancy by the entirety. The correct answer is D. Of course, tenancy in severalty needs all the signatures because there's only one owner, but it is not a form of co-ownership. Tenants in common and joint tenants can sell their individual interests with only their signatures. This action does not convey ownership to the whole property, so the word interest is crucial in this question. Tenancy by the entirety views the interest of the husband and wife as a single interest that can't be sold separately, so both spouses have to sign the deed to sell their interest. Number 32. Who owns the apartment in a cooperative building? A. The individual apartment owner. B. The corporation that owns the building. C. The bank that financed the purchase. D. The individual owner owns the apartment, but the corporation owns the common areas. The correct answer is B. The corporation owns the entire building. The individual tenant owns shares in the corporation and has a proprietary lease that enables him to occupy his apartment. Number 33. Which statement is true? A. All encumbrances are liens. B. All liens are encumbrances. C. All encumbrances are financial in nature. D. All financial claims against property are voluntary liens. The correct answer is B. The statement that all liens are encumbrances is true. Liens, which can be voluntary or involuntary, are just one type of encumbrance, and encumbrances in general can be financial in nature or can limit the use of property. Number 34. Homeowner Bob's house has been foreclosed and sold. He has unpaid local real estate taxes from last year. He owes on the mortgage he took out 5 years ago. And he owes the plumber for work that was done 2 years ago. Who gets paid first? A. They each will receive a proportionate share. B. The bank. C. The town. D. The plumber. The correct answer is C. Real estate taxes take first priority in all liens. After taxes are paid, liens generally are settled in the order in which they were recorded in the public record. Number 35. A judgment lien is placed against you after you lose a court case for an accident that occurred at your home. This means that the lien is placed against A. All your real property. B. The one piece of property where the accident happened. C. All your real and personal property. D. Your salary only. The correct answer is C. A judgment lien is involuntary in general. That means that it's placed without your consent and against all your real and personal property. There may be state-specific laws that limit the judgment being placed to property in the county where the lawsuit took place. Check this out in your state, but in the way this question was asked, this answer is generally correct. Number 36. The electric company needs to put a permanent electric cable across your property to get to a nearby street. The company obtains A. An easement appurtenant. B. An easement in gross. C. An easement by necessity. D. An easement by prescription. The correct answer is B. An easement in gross benefits a person. In this case, the person that benefits is the electric company. An easement appurtenant attaches itself to the land. An easement by necessity is one that must be given to another person by a court order. An easement by prescription occurs against your will by someone continuously using your property. Number 37. The city needs your property for a road widening, but you don't want to sell it. The city probably will take it through its power of A. Cheat. B. Encroachment. C. Prescriptive rights. D. Eminent domain. The correct answer is D. The right of a municipality to take your property against your will for a public purpose is called eminent domain. In Cheat, the state gets your land if you die without a will and without heirs. The other answers don't involve the state or local government taking your land. Number 38. The study of population characteristics is called A. Economic-based study. B. Demographics. C. Infrastructure study. D. Feasibility study. The correct answer is B. Studies of demographics are used for planning purposes in a municipality. Number 39. Which of the following is not necessary for a valid deed? A. Signature of grantor. B. Signature of grantee. C. Description. D. Granting clause. The correct answer is B. The person getting the property, the grantee, doesn't have to sign, though he or she does have to be clearly named, but the person selling the property, the grantor, does. Number 40. On what date does a deed become valid? A. Signing date. B. Delivery and acceptance date. C. Recording date. D. Mortgage approval date. The correct answer is B. Delivery and acceptance is the handling of the deed by the grantor to the grantee, though it is not generally done in any formal manner.